reflective of the stereotyping that we continue to see in the media and in the profession. This must stop now. How does it stop? By this committee taking action and not ignoring its obligation in section and rule 129 AD. The last one from Pabasa says the section 194 proceedings are public and all evidence presented by evidence leaders is live streamed. It was thus inevitable that extracts from the evidence would be shared widely on social media. Greater care needed to be taken by the evidence leaders and the parliamentary committee to avoid the negative and unfair consequences of the screenshot. For example, it is not clear why the names of the advocates were paid the amounts each were apparently paid and is relevant to section 194 inquiry. This is crucial. So relevance in the secondary sense, even assuming the Mazone motion was what it was not. And it says a simple global amount of counsel's fees for each matter could have achieved the same purpose without sensationalizing the names of particular counsel who were simply doing their job we are all paid to do for our clients. And that's signed by the chairperson and deputy chairperson of that body. Now, the last annex, Chair, is the letter from the CEO of Public Protector South Africa to Advocate Skakane regarding his withdrawal from the matter of Oscar Mabuyane. And there basically some kind of mea culpa. They say evidence presented at the section 194 committee is not at the insistence or within the control of the PPSA leadership. In other words, it is at the insistence and the control of the evidence leaders. And then later, they say the members subsequently requested particular evidence. Okay, we've already gone through that. Paragraph 7, which is more important because it goes to the conduct of the chairperson as well. While the PPSA fully appreciates the concerns as encapsulated in the letter, it is noted that the matter was raised directly with the committee on the 10th. The chairperson, Mr. Kyanchi, indicated that members of the committee will not engage on the concerns raised by you and Advocate Mkalwana on the said date and will await formal communication on this matter. And as I've indicated, while that was happening, you simply just repeated or allowed the conduct to be repeated. So that's the gist, chairperson, of the conduct, which clearly has caused a public outcry, rightly so, but is associated with things that this committee should not be associated with: racism, malice, improper conduct, unprofessional conduct, the perpetuating of stereotypes, the predictable prejudicing people's rights, breach of section 22 of the Constitution, you name it. I'm sure this committee would not be proud to be associated with that, or at least to have seen to be turned a blind eye to that litany of complaints from members of the public. So that's, I mean, it would be, I don't even think even a child would understand that that kind of conduct goes to, not just to bias as such, but goes to conduct which should not be associated with any democratic parliament anywhere in the world. But we then go to B2, chairperson, which is the issue of the cross-examination of witnesses. Because this, as I said, that was the last straw of the issue that I've just dealt with. But even before that, there had been conduct which should concern any right-thinking person. And the first one is that the evidence leaders violated the directive by cross-examining Mr. Tembinkosi Muntustole. A witness was called and prepared by the evidence leaders. I'm on 49, yeah. To the extent that the witness felt unprotected by the chairperson until he cautioned the chairperson to be more in control of how witnesses are questioned. This occurred despite an objection from the legal representatives of the public protector, who brought it to the attention of the chairperson that Advocate Bauer was in fact cross-examining the witness. Now, in fairness to Advocate Bauer, she never denied that she was cross-examining the witness. It was only the chair who tried to do that. But I think her assertion was that she was entitled to do so. Well, she was wrong about that. But at least the actual conduct, I don't think no one who's trained in law would mistake what cross-examination is, as symbolized by expressions like "I put it to you" and so on. Well, let me put it this way. It's not just a statement like "I put it to you" that indicates that this is cross-examination. But the most important thing is actually evidence leaders have nothing to put it to you. Evidence leaders are not prosecutors, and therefore they don't have a version to put to any witness. You know, the "I put it to you" statement is meant for a practitioner who puts a version of their own side to the witness, so that that witness must be seen to have been given a fair opportunity before that side, as it were, puts its case. It's very simple basics, law 101. So the mere fact that an evidence leader puts it to you knows that, then it means we're already down the slippery slope. Now, Chairperson, as you know, I said to you, it's not just the Constitution and the directives. The terms of reference, any commission, by the way, this is a democratic republic. So nobody just does something out of the blue. You do things within the confines of that which has been circumscribed by whoever delegated the power to you. Your terms of reference say at paragraph 5 thereof, the inquiry is inquisitorial in nature, and the evidence leader does not act as a prosecutor. Now that's fundamental, Chairperson. It's so fundamental, I don't even know how to emphasize it to this committee. But let me try and break it down. Prosecutors, and I don't have time to give you the entire law of prosecutors, but prosecutors have a duty, even prosecutors, let me put it that way, have a duty to ensure that the tribunal is given fair information, that the fair trial rights of the person are preserved, and that they place in front of the criminal court even evidence that might be helpful to the accused. That's a prosecutor in the first day of training gets told that. That's what you do. If you are found to have not put any evidence simply because it's going to help the accused, then you are not discharging the duties of a public prosecutor, because you are now no longer representing the state, you are representing yourself. Now, if that is the case for even prosecutors, remember, evidence leaders are not prosecutors. Now, when they don't even meet the standard of a prosecutor, then what have we got left? And Chair, as I said, I don't have time to do all the cases, but I can just read out to you some of the extracts. There's a case called S versus Mulula. It says that the court insisted that the prosecutor role was different from that of counsel or an attorney representing a client. Let me pause there. So the difference between the evidence leaders and us is that we are representing a client. They are not representing a client. So the standards by which they are supposed to operate are even different from us, let alone from prosecutors. And it says, the prosecutor stood in a special relationship to the court, since their primary duty was not to procure a conviction at all costs, but to assist the court in ascertaining the truth. Another crucial difference. So even a prosecutor, their duty is not to secure a conviction, but the conduct of these evidence leaders has been that their duty is to secure a finding of guilt against the public protector. So they have not even met the, even if they were being charged by the standard of prosecutors, they would have failed, let alone even the higher standard of evidence leaders. They say that such practice was said to the court to be wrong where prosecutors act contrary. Wrongly supposes an obligation on the part of the accused person to explain the motive of false accusations by their accusers. But in another case, Chairperson called Porritt and another versus National Director of Public Prosecutions, the following was said, that the standard used there is different from that which is used for judges and magistrates, which is obvious. And say, Chief J.A. writing for the unanimous full bench noted that in our adversarial system, the role of the prosecutor makes it inevitable that he or she would be perceived as biased. And I'll say something about this. Let me say it now. What the Supreme Court of Appeal was explaining there was that although there are these standards and the prosecutor is not really representing the state or the people, as they say in America, the people versus so-and-so. It's inevitable because that system is adversarial. It's inevitable that the prosecutor is seen to be representing a particular side there, even if that side is the people. But here, there's no such leeway when you're dealing with evidence leaders. They can't even be seen to be anywhere between being biased. It says, it was noted that prosecutors are required to present the case for the same state firmly, but fairly and dispassionately, even prosecutors. However, the fact that prosecutorial functions are carried out vigorously and zealously, that a prosecutor is partisan and might not hold a very strong view that the accused is guilty, cannot provide grounds for accusal. It follows that the SAFU test is not appropriate. That's what I was telling you about, the one of judges and magistrate. And says, however, recusal of a prosecutor on the grounds of bias or apprehension of bias arises where the bias of the prosecutor affects the accused's right to a fair trial. That's the gist. That's what the Supreme Court of Appeal said. In other words, all this may or may not be, they might be perceived or whatever, but the minute it affects the procedural fairness rights of the person, then the prosecutor must be removed. It says, Chikli referred to a case in Zimbabwe of Smith with a Y, S-M-Y-T-H, versus Ushe Wokunze, where removal of the prosecutor was necessary because the accused's fair trial right was placed in jeopardy by the vindictive manner of the prosecutor and his dishonesty in deliberately misleading the court. So conduct unbecoming, as it were. And the judge said sufficient structural guarantees in South Africa to ensure that an accused's right to a fair trial is protected, irrespective of whether the prosecutor concerned is an employee of the NPA or an outside counsel funded by SARS or any other entity. So even if it's outside counsel, like in your case, the standards apply. So, Chair, this is the most crucial submission, which is that your terms of reference, your directives say that the evidence leaders, by the way, that states the obvious, should not act as prosecutors. In other words, you yourselves as Parliament have decided the standard. You say they must not act as prosecutors. But what we're busy showing you is that the standard of evidence leaders is even higher than that. But if they can't even jump this hurdle, which is lower of prosecutors, then it's impossible that they could have jumped the higher hurdle of evidence leaders. I mean, that's just a matter of logic. If anyone who has ever watched high jump at school will understand it. If you can jump 1 meter, then you surely cannot jump 2 meters. It means, so if you fail to jump even the lower bar, then you, as a matter of logic, cannot be seen to have jumped the higher bar. So that's what happened there, Chairperson. The issue of that cross-examination, which is not allowed by any standards. There's a reason. This is the reason, what I've just explained, Chair, why your directives say at 6.8. If it can please go to 51.1. Okay, let's just do 51, the whole 51. I'll read while you're putting it up. I say, Chairperson, the point I've just made, there is a very good reason why the applicable directive clearly differentiates, there should be an S there, between the right of the public protector to cross-examine and the right of the evidence leaders to, quote, put questions. So that terminology was deliberate in your directive, which you adopted here in July. It says, we have a right, it makes the point I was making that we should even be judged by a different standard. We have a right to cross-examine and they have a right to put questions. The evidence leaders have no right to cross-examine simply because, unlike the public protector, they have no version to assert or test by way of cross-examination. Neither do they have a right to, quote, discredit any witness. That can only be done by a person or a party which has a version and a desired outcome, which is in conflict with the evidence of that particular witness. That is the sole purpose of cross-examination. For that reason, it is clearly important to illustrate the point. So unless if you have an objective, an outcome that you want, you can't put a contrary, so-called contrary version to the one that you think is helpful to the other side. And we say clause 6.8 of the directive there makes that clear. It says, after the evidence leaders have presented the evidence of a witness, the public protector may cross-examine the witness. But look what it says when it comes to the evidence leaders. At 6.16, after members have posed questions, the evidence leaders may ask any question arising or seek clarity from the witness in relation to questions posed by witnesses, whereafter the chairperson shall excuse the witness. That's it. Once the witness is excused, there's nothing more you can do. So the evidence leaders have a right to do two things. One, pose questions arising or seek clarity. That's after the members. And sorry, I'll find the other. There's another reference that's missing here in paragraph 6. And that's the one where the evidence leaders also put questions. But anyway, I think everyone here now, by now, knows that
Thank you. Thank you, Advocate.
there's no in the.
Thank you.
No, Chair, I'm left with.
I'm not asking for that. I'm now saying thank you, Advocate Mpofu.
Yeah.
I think it's good. You must listen to me as a chair.
Okay. No, I'm saying, Chair.
No, wait.
I know we want to have tea. I'm saying, can I just finish this?
To anticipate what I'm going to.
Okay.
This is what is going to happen now. The time is 11:31.
31. Yeah.
We're now going to take a break for 15 minutes. When we come back, the following will happen. Firstly, we would have started at 9:30. And as a chair, I would make the remarks until 9:37. I hand it over to Advocate Mpofu at 9:38 and use that time to place matters on record, including challenging the time. At 10, we had an audio problem. We resumed 6 minutes after 10. At 10:14, Advocate Mpofu started with the application, and I would have given him that hour. So at 10:15 or 14, that would have been the end of that hour. I added 15 minutes until 11:31. So I'm making that point to say we're taking a break now That's a time I've given to Advocate Mpofu. I'm not giving any additional time. When we come back, I'm going to ask members to seek any clarities, if there are clarities that they need, and thereafter have a brief session of the committee to discuss as a committee. We take a break. Thank you.
Chairperson, before you take the break, I want to indicate that I'm not finished with my presentation or making my application, as I indicated. So whatever you do henceforth, you must be on the understanding that I've not finished and I have some very important submissions still to make on this important application. And in fairness, you should allow it. If I were you, I would allow it at least to be finished, even if we know what the outcome is going to be.
Thank you, Advocate Mpofu. The point I'm going to make is that we have received your written submission, we have read it, given you an hour to make that. I'm giving no more time on your oral presentation. We take a break. Thank you.
Recording stopped.
Following up on our commitments to the people, making your future work better. Parliament TV, Channel 408 on DSTV.
The Parliament of the Republic of South Africa is the site of democracy and an embodiment of key pillars of our Constitution. The parliamentary precincts tells the history of South Africa's past and expresses the aspirations of our society as envisaged in the Constitution of the Republic of South Africa. The buildings and the precincts speak of the country's Dutch and British colonial conquest and disposition, of the people captured in places such as Madagascar, Mozambique, South and Southeast Asia, and brought as slaves to the Cape Colony. A modest plaque in Spin Street marks the place where slaves were auctioned, and the slave lodge at the Parliament Street entrance to the parliamentary precinct bears testimony to the slave trade in the Cape Colony. The precinct and its buildings speak also of apartheid, the zenith of institutionalized racial segregation and oppression under white minority rule, most enthusiastically enforced from 1948 to the early 1990s. Since April 1994, the buildings and grounds of Parliament have spoken of a non-racial South Africa, founded on advancing human rights and freedoms, achieving equality and the supremacy of the Constitution, which was adopted in 1996. In 2014, the parliamentary buildings and precinct were declared a National Heritage Site. As the South African Heritage Resources Agency said at the time, this was because of the aesthetic design of the buildings and the scientific value of the site. It was a reminder of the first European settlement at the Cape and its introduction of alien vegetation layered with a range of historical moments relating back to water courses and primordial people's use of their space. This is the oldest section in the precinct of Parliament. This is the National Council of Provinces, where it represents all the 9 provincial legislatures. This building was built from 1875 and it was completed in 1885. There were 2 architects involved. One of the architects was Charles Freeman, but the whole project was completed by a Scottish architect known as Henry Greaves. Then from 1885 until 1910, this is where the Cape legislature was housed. There were 2 houses. One was the Legislative Council and the other one was the Legislative Assembly. This is the Queen's Hall, named after Queen Victoria, who gave permission for the establishment of Parliament in the Cape Colony. You can see in here the British-era coat of arms for the Cape Colony. With the unification of South Africa in 1910, this building was added to the original 1885 building, and a new chamber for the Union of Parliament was built. It was used for this purpose until 1961, when South Africa became a republic. It was in this chamber on the 6th of September 1966, during a sitting of Parliament, that a parliamentary messenger, Dimitri Tsafenda, stabbed to death the Prime Minister and the architect of apartheid, Dr. Hendrik Verwoerd. This is the original desk where Dr. Hendrik Verwoerd was sitting on the day he was stabbed to death. Strategically placed at the heart of the South African Parliamentary Precinct, the former British High Commissioner's Office is a reminder of colonial links with the British Crown. This sandstone building was designed in 1937 by the architects John Perry and Lightfoot, who won an architectural award for it. The building was sold to the Department of Public Works in 2003. It was renamed Africa House and is currently used to house the Joint Standing Committee on Intelligence and officials of Parliament's administration. The emblem on this building symbolizes the English monarch. This emblem has a French motto, Je et mon droit, meaning God and my right. It implies that the monarch of a nation has a God-given or divine right to rule. And King Henry V adopted this from the French. The shield is quartered, depicting in the first and the fourth quarters the three passant guardant lions of England, in the second the rampant lion, and the double treasure pattern of a shield of Scotland. In the third is a harp for Ireland. This building was commissioned by businessman and financier Sammy Marks as his Cape Town offices in 1904. The architects were Francis Mazzei and Sir Herbert